4 years ago, I remember talking with disappointment after the Supreme Court had taken a case of massive importance and reduced it to meaninglessness, skirting everything that made it important. It was the famous case of Jack Phillips, the owner and operator of Masterpiece Cake Shop in suburban Denver, who refused to bake a cake for a gay wedding. The state of Colorado, through their anti-discrimination law, tried to force him, and Phillips appealed his case all the way to the Supreme Court. And of course, he did ultimately win the case, but only on terms that didn't actually address the issue. In a decision written by Justice Kennedy, the court decided 7-2 that the state of Colorado had acted with particular hostility toward Jack Phillips' faith, that if only the Colorado Civil Rights Commission had just been a little bit nicer about it, more respectful and more neutral in its treatment of Jack Phillips' religious conviction, then this would have been fine. But since Colorado was mean, well, Jack Phillips wins. And if that is any exaggeration, it's not much. The court did not address whether this sort of speech coercion could be done in general. It only addressed the way it was done in this particular case, meaning the court did nothing to stop the state of Colorado and the vindictive activists who targeted Phillips from doing this again, the court perhaps hoping they would just go away. But that's the thing about vindictive activists, they don't. They exist to browbeat their enemies into submission, and so they got right back to work. So even though it's not at all surprising that the easiest prediction of all time that this case would get revisited has in fact come true, I am still somewhat surprised by just how similar this revisitation is. All of the facts are almost identical. Same location, suburban Denver. Same law, the Colorado anti-discrimination statute. The same lawyer arguing the case, Kristen Wagoner of Alliance Defending Freedom. And of course, the same issue, compelled speech and labor for gay marriage. One of only a few slight differences I see is that in this case, no gay couple even sought the services of this woman, Lori Smith, a website designer in Littleton. She has not had to tell a same-sex couple she will not work with them. She challenged the Colorado law in court herself. So the alleged victims in this case are only theoretical. But other than that, the facts in this case are nearly identical to Phillips. Smith creates wedding websites, but she only wishes to speak through God's lens, as she describes, so she wants to post on her website that she will not create same-sex wedding announcements because they conflict with her faith-based view that marriage is a union of a man and a woman. In other words, she wants to speak by posting on her website and to refuse to speak by choosing what to say or not to say. The core of this case is pure speech, as in spoken or written word. In the cake case, there was some dispute about whether cake artistry is in fact speech, not just the words on the cake, but the construction and the display of the cake. Does that count as speech? In this case, it is purely about written word. I want to be free to write what I want, which includes freedom from coercion to write what I don't. But of course, if all the same facts are coming back for the sequel, then so is all the same tortured logic. At the hearing on Monday, many of the justices made the arguments much more complicated than they need to be. The justices and the lawyers battled the bulk of the 2+ hours over distinctions between speech and labor, under the theory that it's generally constitutionally okay to compel labor, but not constitutionally okay to compel speech. We can force you to serve people, we just can't force you to say things while you do. So is building a website providing a service, or is it saying things? That's the debate, which to me is a frustrating one because on moral terms, neither is square. You don't get to force a person to work. You don't get to force a person to speak because you don't own either of those things. That person does. But I get it. The court is not here to judge moral standards. The court is here to judge legal standards. And as a legal standard, the protections against compelled speech are much stronger than the protections against compelled labor. Even though you have a constitutional right to the property that is your labor in pursuit of the compelling state interest that is public accommodation for everyone, these anti-discrimination laws that force businesses to serve everyone are well established and well upheld, but there is no corresponding legal doctrine to force businesses to say certain things while doing it, or at least a much weaker one. But even if that is the legal doctrine, doesn't make it any less frustrating as a moral matter, because there is another word for compelled labor. It's slavery. If you and only you own the property that is your labor, well, then it's wrong for anyone to steal it from you for any reason, even for serving the rainbow, the highest of all callings to many. But fine. Philosophy aside, for First Amendment purposes, we will say that speech is different from labor. I see how the court gets there legally, even if I do think it's morally bunk. That same speech versus labor debate from the prior Cake case returns and gets expanded in this one. Is Lori Smith, the website designer, more like a book author who we can't force to say a particular thing in her books, or is she more like a caterer who isn't speaking in any way?
So if you win this case, if you prevail here, and the next case involves a caterer, at least your position here is that's different.
I won't be coming back with the caterer, but I will be coming back with perhaps a custom wedding cake or a cake that has a symbolic meaning to it.
The caterer ordinarily wouldn't have the same right that your client here does, who's a website designer.
Well, that is news to Subway. The court is going to have to tell them that making sandwiches is not, in fact, artistry, though, in fairness, I think we've all had our share of less than artistic Subway creations. Regardless, that debate about what is labor and what is speech gets frustrating in this case at levels way beyond the prior Cake case, because in this case, even speech isn't speech, at least according to a few of the justices. Compelled speech isn't a problem if it's purely informational speech, for example, not endorsement. We can force you to say that the wedding is at 3 o'clock. We just can't force you to say that it's awesome.
What is the speech that your client is required to provide? It is to announce a wedding. I mean, this is a standard site, there's not a whole lot of, gosh, isn't this great? It's just like, here's the registry. It's announcing the wedding. It's announcing where to get the hotel reservations. What's the speech that's been required of your client?
Yeah, what speech is being forced? Other than the words that were forcing you to write on that website. It's not forced speech because it's not your speech. You're just writing somebody else's schedule of events. That's the apparent logic. Just like it's not forced speech if it's biographical in nature. It's somebody else's story, not yours.
Show me a page on that website that is an endorsement of a marriage as opposed to the story of a couple.
Well, either one violates the compelled speech doctrine.
No. Our photo gallery, funny dating story. How is that your story, your photo gallery? I don't understand. How is this your story? It's their story.
So if you write stories in general, you can be compelled to write somebody else's story. It's compelled biographies for everyone. We used to call telling stories at gunpoint a hostage situation. Now it's somehow the apex of freedom. I'll be sure to include that enlightening philosophy in my forced biography of Sonia Sotomayor. After all, I write stories for a living, so if she tells me to tell hers, I have to. I just hope I get some discretion in the title. Fortunately, the bizarre position that some speech is not actually speech, if we want to force it upon you, is not a popular one on this bench, however. So I predict a more solid outcome in this case than the prior Cake case, for both of the obvious reasons that this case is more purely about speech as in written word than the Cake case was, and because the membership on the court has since shifted. Kennedy, who wrote the Cake opinion, is gone, replaced by Kavanaugh, and Ginsburg has been replaced by Barrett. So both the facts and the circumstances have shifted in favor of freedom in this case, but there's another key shift as well: the quality of the state of Colorado's argument. Colorado's lawyer in this case tied himself into knots so complicated that even the wise Latino wing of the court might have a few questions. First of all, he betrayed the ideology by granting Barrett's hypothetical that the state of Colorado could force gay activist websites to announce and promote straight weddings.
What if we say that it's a gay rights group that wants to publish gay rights announcements, and so it publishes only same-sex marriage announcements and turns away opposite sex. Can the gay rights organization do that?
In this unusual hypothetical, they cannot turn away announcements based on the protected characteristics.
They can be compelled to give their web space to those announcements, even though it's not consistent with the message of their organization, assuming they're public accommodation.
They can do that.
Credit for consistency and honesty, I guess, and keep that in mind as a possible revenge angle later forced the San Francisco gay bars to host fundamentalist Muslim weddings and then enjoy the show. But other than that brief consistency, this lawyer was logically incoherent. He agreed that speechwriters can't be forced to write speeches with which they disagree.
The notion that Colorado could compel, for example, an individual to write a speech or a press release on behalf of, say, a religious entity with whom he or she disagrees. Does every press release writer, freelance writer, have to write a press release for the Church of Scientology, say, even though the beliefs of that institution may be inimical to that person?
Not at all.
He agreed that publishers can't be forced to publish material with which they disagree.
Does the publishing house have a First Amendment ability to select the kinds of books that it will publish along the lines of my hypotheticals there?
Of course it does.
It would still have a First Amendment right, correct?
Yes.
Sure about that?
But if you build a website, well, then suddenly it's totally different. Somehow those words that you type on the same keyboard and post on the same internet, if somebody forces you in that context, well, then it's not compelled speech anymore.
And they say there is no serious question, their words, no serious question that this case involves compelled speech. Do you agree it involves compelled speech?
No.
Even though they say there's no serious question that it does. You disagree with that?
We disagree with that.
Yeah, see, it's not compelled speech. It's just words that you have to say if a gay guy tells you to.
How can you disagree with that? Because if it's speech and she has to say it, why isn't it compelled speech?
The company is going to provide speech, and the company says, no, I will not provide that to you. And the only reason is because of who you are. That's not compelled speech.
This guy lassoed himself with his own tortured pretzel logic about why it's okay for the government to force you to say some words, but not others. Ironically, the better strategy for him probably would have been just to similarly point a gun at the justices to force them to say things that they disagree with too, because it's pretty apparent listening to the argument that a sufficient number of them see this for the absurdity that it is, not just as a matter of constitutional law, but as a matter of basic logical consistency. Still, I won't allow myself to get too optimistic for the outcome in this case, even though I do think that the constitutional and moral principles at stake are as clear as they could possibly be. But what is also clear is that this court is looking for ways to narrow the scope of this decision too, as is the hallmark of Robert's tenure. In agreeing to hear the case, the court refused any arguments about free exercise of religion. So there won't be any answers here about whether you can be compelled to behave or work in ways contrary to your faith. The court also refused to hear arguments to overturn a 1990 decision that says laws with neutral, general applicability are fine under the Free Exercise Clause, even if they hinder or prohibit particular religious exercises. So this decision will only be about the speech issue, not the religious exercise issue. And if you listen during the arguments, some of the justices are still looking for ways to compel the labor, but allow for free expression. So you still have to build the website, but you can write that you disagree with it if you want to.
If the standard announcement is made with love by Amber, who believes that a valid marriage is a union between one man and one woman, that's okay.
If that's on every website, yes.
And it's not that Alito endorses that idea. It's just the idea that's being tossed around the court, one that defies First Amendment fidelity, but also just basic logic. It is still forced speech, even if you're allowed to add footnote commentary to it. The point is the speaker does not want to say it. So if he's entitled to voice disagreement about it later, he's just as entitled not to voice agreement in the first place either. Not to mention how ridiculous it is from a business perspective anyway. Who wants to buy a product that the producer doesn't want to make and explicitly disagrees with anyway? Would you buy an electric car that the government forced the manufacturer to make if the manufacturer put out a press release and engraved into the car that it's a crap product that they don't support. Regardless, the court does sound poised to add some clarity to the compelled speech doctrine in a decision coming in the spring that may actually apply some limitations to the activists this time, if not for the principles of the matter, perhaps just by the annoyance of their persistent badgering. They've badgered the court almost as aggressively as they badgered Jack Phillips himself at this point. The deal that you sold was that you wanted to be left alone. And if that is such a basic request to which everyone is entitled, well, then by all means, please start granting it. Thanks as always for listening and for supporting this channel. Always appreciate that thoughtful discussion down below and especially over on Parler, that is at ML Christiansen. You're always welcome to coming out and chat in my live streams. Those are linked down in the description. Looking forward to it. Goodbye.